I would like to call the meeting of the August 2014 Tennessee Auctioneer Commission to order. If you would, call the roll.
Bobby Colson.
Here.
Ronnie Collier.
Here.
Jeff Morris.
Here.
Howard Phillips.
Here.
Gary Cunningham. Absent. You have a
Okay,
quorum,
if you
sir.
would read the notice of meeting that was published, please.
Absolutely. This meeting's date, time, and location have been noticed on the Tennessee Auctioneer Commission's website, included as part of this year's meeting calendar since August 16th, 2013. Additionally, the agenda for this month's meeting has been posted on the Tennessee Auctioneer Commission's website since August 4th, 2014. This meeting was also noticed on tn.gov's website.
Okay. We don't need to approve that or anything, just have to
sir.
read the notice,
Just
okay?
have to read it out loud.
Next on the agenda is officer elections. It's always been customary for us to elect a new chairman and vice chairman of the commission at the August meeting. At this time, I would entertain nominations for chairman.
I'd like to nominate Howard Phillips as chairman for the upcoming.
2015, there you go.
I'll second.
It's been moved and seconded. Are there any other nominations? All those in favor say aye.
Aye.
All right, Howard. And we'd like to get nominations for vice chairman.
I would like to nominate Ronnie Collier for vice chairman.
Second.
Moved and seconded. Ronnie be vice chairman. All in favor say aye.
Aye.
All right, Howard, you have the floor.
Well, I appreciate that, guys. We have a great chairman for the last year, and we've had good meetings. And I think that I'd like to make a motion that he continue and do today's meeting, if that's all right with everybody.
That's okay. I'd be glad to. If you would, let's review the agenda that's in front of us, and we'd like to adopt that agenda into this meeting. This one's got Bobby's name on it. There we go. I don't think it matters much.
I don't think-
My apologies. They're
I don't
identical
know. I
except for
didn't
the
look
name
at yours.
tag.
Yours may be different.
There we go. Mine's got the $100,000 check in it. I mean, that's the only difference in that.
Mine's 100 feet. I'll move it. We adopt the agenda.
Second.
Moved and seconded. All in favor say aye.
Aye.
All right, it's been moved and adopted, the agenda for today. Same holds true for the minutes from last month's meeting, or the last meeting, which was in June. Been moved. Is there a second?
Second.
Seconded by Ronnie. All in favor say aye.
Aye.
All right, so we have the minutes. Ressa, would you like to come forward and give us a education provider update? Ressa or Hanson. Nashville Auction School, there we go.
Good morning, I'm Ressa Orr Hansen with Nashville Auction School, and this update will be short and brief and to the point. We are scheduled for September 22nd at the Millennium Center in Johnson City, Tennessee. We have courses up for approval later this afternoon for T. Kyle Swicegood out of North Carolina to present on salesmanship. That was a request that we had from attendees at last year's seminar on things that they would like to receive as education forthcoming. And then Mike Brandley from the Ohio Auction School on ethics to do the seminar he presented for NOLOA for the Tennessee Auctioneers. So
Mike's presentation on that is very, very good and very timely, and so I think there'll be two great courses that will be up there in Johnson City, and we encourage everybody to attend.
we do too. And of course, we made some last minute changes on the newsletter to make sure that we got the rules published and distributed to the licensees. So we've got a jump start on the next newsletter, but of course I always welcome, Mr. Chairman, whoever and other commissioners, input from the commissioners and any articles that y'all would like to write or anything that you would like us to cover or address. The main topic for the next newsletter is going to be addressing things like bird dog fees and referral fees, that sort of thing. So that's my report. Thank you.
They always come about, but never on a legal basis sometimes.
Chairman, the course information for RESA's, for the continuing education seminars are on tab 2.
Okay,
I don't know if it's customary that you vote and approve those.
typically not.
Okay.
Well, I think it's good that they do it, and we know what's being presented, but I think that'll be just fine. Julie, would you like to go ahead and get into the legal report?
This over here. We have a pretty short report today, but the first matter, let me see, what tab?
Tab are we on here?
Believe it is tab 3.
What do you do to make 3 go?
Let's see, just go.
It is under tab 3 on your iPads. Just let me know when y'all are ready.
I think everybody is, let's see, you gotta get on page 1, Ronnie. There you go.
Okay, the first matter is 2011-030171, and this was originally presented at the January 2012 meeting. It says, complaint filed against respondent by complainant who purchased a jet ski at an auction and received title upon the purchase but has never received the jet ski. Complainant paid $7,345, which included the purchase price and a 15% buyer's premium. Respondent failed to answer. He and his company are unlicensed. The recommendation at that time was a consent order for a civil penalty of $1,000 for failure to account for funds belonging to another under 6219-112B4 and $1,000 for unlicensed activity under 6219-102. The action taken was Mr. Alexander made a motion to authorize a consent order for a civil penalty of $1,000 for failure to account for funds belonging to another under 6219-112B4 and $2,000 for unlicensed activity under 6219-102. The motion was seconded by Mr. Colson and the motion carried. New information was recently received from respondent through an attorney, including but not limited to an auction advertisement for the subject auction, as well as a consignor statement with a description of the items sold at the auction along with prices, which appears to include the jet ski purchased by complainant. This documentation states that the subject auction took place in a neighboring state and not in Tennessee, as originally believed when this matter was first presented. Additionally, documentation submitted by respondent through his attorney indicates that respondent conducted the subject auction in the neighboring state with a license in that state. Respondent's attorney states that the auction was conducted in the neighboring state in full compliance with that state's laws and regulations. Respondent's attorney states that in winding up and clearing out the final sale items, some items were stolen from the warehouse, including the jet ski purchased by complainant. Respondent's attorney states that respondent informed authorities but was not permitted to file a complaint or press charges since respondent was not the owner of the items stolen. Respondent's attorney states that complainant was made aware of this, and respondent's attorney does not know what actions were taken by complainant to recover the property. Based on this new information, it does not appear that there was unlicensed activity in Tennessee by respondent, and it appears that all activities occurred in another state. The recommendation is to dismiss this.
You able to determine for a fact that it was in a neighboring state?
Like I said, we had been asking for this information for a while. This was actually scheduled to be a formal hearing in the upcoming future. They kept telling us it was in another state. We asked for the documentation, and we did finally receive that from the respondent's attorney. That's what we were waiting on because we didn't want to represent it just based on what they were claiming. What we received from the attorney included the licensing information in the other state where it took place, an advertisement of the actual auction that took place, which has the address, which is located in the other state, not in Tennessee. Also, the consignor statement. I don't believe that does have an address on it of where the business is located, also in another state. And
why would the complainant file a complaint in the state of Tennessee?
I'm
if
not
that
sure.
is a fact?
This complaint actually predated my service with the commission. I was not here yet at that point. But in looking at the complaint, it appears the complaint was very short. I believe it was submitted as an online complaint with no documentation. I believe that this individual had an address in Tennessee, or maybe the complainant lived in Tennessee. And the respondent had an address in Tennessee, However, I guess that person went off the address that the person had in Tennessee because the information submitted with it had no address on it. And I believe it might have been an auction that the complainant participated in by telephone. Is that correct?
It was an online auction.
An online auction. And I'm sorry, Miss Ryan found out most of this because she was preparing it for a hearing. But like I said, the information we had at the time of the complaint, it looks to have been pretty bare bones. And Miss Ryan was preparing this for hearing, and with Miss Smith's help, gathered this additional information, but waited until they received some documentation through the attorney before bringing it back to
And
you.
are y'all confident that all the activity was not in this state? Okay.
If this was an online auction, then the buyer was in the state of Tennessee, correct?
Yeah, the buyer's address
Well,
in
that's
the
what she
complaint
said.
file. Yeah, yes, the buyer's address is in the state of Tennessee.
Well, doesn't the state of Tennessee protect the buyers buying merchandise from another state in an online auction?
Well, I don't believe this person would have been engaged in unlicensed activity if they weren't in this state.
The activity wasn't in this state.
The activity wasn't in this state. The auction didn't take place in this state.
That's what I love about online auctions. You can cheat anybody any way you want to, as long as it's in another state.
Any other discussion?
I move that we take legal's recommendation.
To dismiss.
Yes.
Is there a second to that?
I'll second.
It's been moved and seconded to dismiss this case. All in favor say aye.
Aye.
Aye. All right, next.
Okay. 2014008551. Complainant is a licensee who states that respondent, a firm, advertised that as part of an estate auction, a van would be auctioned. Complainant states that respondent does not have an auto auction license. Respondent submitted a response through its principal auctioneer and owner, stating that respondent was contacted by a client from another state regarding selling the individual's late father's estate. Respondent states that the auction consisted of several items which were a portion of the estate, including a van and a sailboat which was not in working order. Respondent states that the completion of the sale items of the estate was accomplished in May 2014. Respondent's owner, principal auctioneer, states that it is his understanding that items of personal property such as these associated with a deceased person's estate can be consigned for auction, but motorized vehicles not associated with an estate require the auto auction license. When examining the laws and rules of the Motor Vehicle Commission, it appears that there's an exemption found at Rule 0960-01-.181A relating to motor vehicles in estate sales for up to 5 motor vehicles. Respondent might benefit from a letter of instruction regarding that rule. Therefore, the recommendation is a letter of instruction regarding Rule 0960-01-.18.
This state, you can sell vehicles in an estate auction. I don't see any violation there whatsoever. I don't know why they were complaining about
I
it.
pulled the actual rule, and it appears to say that up to 5 motor vehicles owned and entitled to the individual decedent may be placed for sale at auction with the decedent's other personal property. So
I do it myself. So.
it appears that these two individuals might be competitors, and maybe just not, somebody wasn't aware of this rule. But
Always
I thought
is. Any discussion, guys?
I'll make a motion to accept legal's advice.
Then moved and seconded to accept legal advice. Just send the guy a letter to explain that he was perfectly in his rights to do so under that rule. All in favor say aye.
Aye.
Next.
2014009191. Anonymous complainant states that a property was advertised by respondent, Firm Branch, as a commercial property, and complainant attached photos of a sign advertising the auction. Complainant states that complainant had a client interested in the property, and in doing research, complainant found that the property is neighborhood commercial, not commercial, and restrictions would not let a gas station be built on the location. Complainant states that there is a big difference between neighborhood commercial, and complainant states that buyers and realtors need to be aware of the difference because there are more building restrictions with neighborhood commercial. Respondent submitted submitted a response through its principal broker / principal auctioneer stating that in the town where the property is located, there is no individual category known as commercial zoning, and there are instead many categories which are commercial specific. Respondent attached a chart of permitted land uses by zoning district for the city. Respondent states that it would be impossible to adequately advertise on a location sign each individual type of commercial zone, and in order to address the issue, respondent provided an information box on site with brochures. A copy was provided, which note that the property was neighborhood commercial. Respondent states that all advertising provided that announcements on the day of the sale supersede advertising, and it was announced on the sale date that printed copies of zoning regulations were available for inspection. Respondent states that advertising reminded potential buyers to perform their due diligence. Also, respondent states that a survey plat provided on the sale date addressing the zoning situation and all relevant regulations, including construction setbacks and the information on the survey plat, was available on site from the beginning of advertising until the date of sale. Based on all the information provided, it does not appear that there's a violation by respondent, and the recommendation is to dismiss.
Is there any discussion regarding this case?
Make a motion, we dismiss.
It's been moved
Second.
and seconded that we dismiss this case. All in favor say aye.
Aye.
Next.
2014-010011. This is a complaint opened by TAC based on information received advertising that respondent, an unlicensed company, was conducting a Chapter 7 bankruptcy liquidation auction consisting of multiple real estate parcels within Tennessee. Respondent submitted a response through its managing partner attaching an order signed by a U.S. bankruptcy judge authorizing retention of respondent as auctioneer to the bankruptcy trustee. Respondent states that it hopes that this satisfies the Commission's concerns. An investigation was requested and an investigator attended the subject auction. The investigator indicated that respondent's managing partners were made aware of the laws in the state of Tennessee relating to the auction but continued. The investigator stated that there were not any sales due to the only bidder leaving early. It appears to legal counsel that although respondent argues that it was authorized by a U.S. bankruptcy judge to be retained by the trustee to auction this property relating to a bankruptcy, the licensing exemption found at Tennessee Code Annotated Section 62-19-103, subsection 1, which states the provisions of this chapter do not apply to any person acting as a receiver, trustee in bankruptcy, guardian, administrator, executor, or other such person acting under order of any court does not apply to respondent. The recommendation is to authorize a formal hearing with authorization to settle by consent order with a civil penalty and amount to be determined by the Commission for violations of Tennessee Code Annotated Section 62-19-102, A1 and 2. If there are any questions, I'd be happy to answer them.
I have a question.
I'm going to make a statement that I'm going to recuse myself from being involved in this case.
All right.
My question is exactly what happened.
The auctioneer commission staff was given notice that an unlicensed company, not licensed as an auctioneer or a real estate company in the state of Tennessee, was auctioning multiple real estate parcels. The company was contacted. I actually contacted them myself. A complaint was opened prior to the auction, letting them know that it appeared that they were in violation. Their stance was that they were covered under this exemption. They provided a copy of a court order, which basically authorized the bankruptcy trustee to appoint this unlicensed company by name. They were named in the order as the auctioneer. They operated under we had an investigator attend the auction. I informed them that based on my reading and my understanding of how you all had interpreted it, that it covered the trustee themselves, but not just any company that was hired pursuant to an order. They persisted, as you could see. The investigator attended to see what would happen. They basically said they understood what the point was, but that they were operating under the assumption that they were covered under the exemption. They held the sale, but no items were actually sold, according to the investigator, because the only bidder left.
But the key thing is they held the sale, and I was a little bit confused. Now, the bankruptcy trustee is probably an attorney, correct? Most of the time. Well, most of the time they are.
You know, I'm not sure it's stated in the order. I think sometimes.
Anyway, he is the one that appointed an unlicensed company to do the auction.
Actually, a judge specifically named this company.
Does he not hold some responsibility too?
The judge, it's a federal, of course, bankruptcy court, but it's in a district within another state completely. I'm not even sure that this judge would have been aware, that we have licensing requirements in this state or the situation. It's, it is a federal court, but the district in which this bankruptcy court is located is not in Tennessee.
Bankruptcy court was not in the state of Tennessee,
No,
but the
sir.
property was.
Not even a neighboring state.
Okay.
Was I will once I gather my thoughts. I'm trying to not get all on tape. Was the auction company specifically mentioned in the court order?
Yes, it
As
was.
being hired by the federal court?
The title of the order actually was authorizing retention of name as auctioneer to the Chapter 7 trustee.
So it's not, okay, because I was thinking maybe it might have said it's authorizing
An auction
Ronnie Collier
company,
trustee to hire somebody.
No, it
the
specifically.
company's name, the court is actually, the judge actually, boy, wow.
Still not covered.
I mean, I've just never thought about it that way. I think you're right, but I don't know. I guess I just always assumed that if it was if the name of the company was in that court order, that they were pretty much covered. But when you read this, it really doesn't say that.
Well, if the trustee had done the sale himself and he was in Tennessee, he would be covered. They have the authority to do an auction with a license. I make a motion that we accept the recommendation, authorize a formal hearing.
And the amount for the consent order, I did leave up to you all. The range for civil penalties for a violation of 6219-102A1, which is the requirement to have an auctioneer's license, states that no one shall advertise to be an auctioneer, apprentice auctioneer, or firm without holding a valid license. The range for that is $0 to $1,000. The range for 6219-102A2, which deals with conducting or offering to conduct a real estate auction without having an auctioneer's license and a broker's license, the range for that is $0 to $1,000. And I wanted to discuss this and then let the commission determine the amount they felt.
Was it an auction company from another state that wasn't licensed in Tennessee?
Yes, sir. They are based in another state.
So there is two rules broken, two laws broken, and it could be a fine for each one.
It's two subsections of the same statute. They're both within 6219-102, but within our rule, there is a specifically defined penalty for each subsection. That's not the case with all rules, but in this one it is.
I make a motion that we give them a penalty of $1,000 for each violation.
Howard's made a motion. Is there a second to that?
I'll second.
Been seconded by Ronnie Collier. All in favor, say
All right, well,
aye.
hang on a
Whoa,
second.
whoa, whoa, excuse me,
All right, well,
discussion?
Discussion, yeah. And the only reason I'm saying this is I want to make sure everything's worded right, because Howard said a penalty, but this says this would authorize, or what we're doing is authorizing them either for a formal hearing or to settle it with this $2,000 penalty.
Correct.
Right.
Basically, I had recommended authorizing a formal hearing with a consent order, and I just left the amount basically
Okay.
blank, and Mr. Phillips was just filling in
Okay.
the amount he felt appropriate.
So if they pay the $2,000, then,
It's
It
over
would
with.
settle the matter without a
Okay.
formal hearing,
It'd be a
yes, sir.
consent
All right.
order settlement
Right.
of $2,000.
sound good to me.
Any more discussion? All in favor, say aye.
Aye.
Motion passes.
Okay.
Item 5.
Last item, 2014-01-3371. Complainant states that complainant attended an auction conducted by respondent, a firm. Complainant states that complainant bid up to $5,000 per acre and won a tract, but was told when complainant went to settle that it was $7,000 per acre. Complainant states that they made complainant write a check, which complainant later canceled. Respondent submitted a response through, it just should be one respondent. Respondent submitted a response through its principal auctioneer stating that complainant's allegations are untrue. Respondent states that a farm was offered in multiple tracts to be sold by the acre high bidder's choice. Respondent states that complainant bid $7,000 per acre to lose the bid to another bidder at $7,100 per acre on the previous round, and then complainant won the bid at $7,000 per acre in the following round. At the end of the sale, respondent states that contracts were filled out and no one complained or challenged the sale price, and complainant was not intimidated. Respondent states that respondent later received complainant's return check, and after several attempts to contact complainant, respondent's attorney sent a letter which was returned, and respondent has been unable to contact complainant. Respondent provided a contract for sale of real estate which was executed by both the complainant as buyer and the seller, which was for an amount representing $7,000 per acre for the amount of acreage respondent states was sold. A copy of the letter from the attorney which was returned, a copy of the handbill, and a copy of complainant's registration, which respondent states contains a false address. It does not appear from the information provided that there is a violation by respondent, and therefore the recommendation is to dismiss.
Have you heard from the complainant since the complaint was filed?
No, I haven't. I contacted the respondent because they responded with the information, but I wanted to see a copy of that executed contract.
Right.
And when it was given to me, the amount added up and it was fully executed by both the parties. The respondent says that, they would be happy to collect statements. There were people there, but apparently the seller's kind of an elderly individual and didn't want to put the person through that if it wasn't completely necessary. And to me, the contract appeared to be very telling that this complainant executed the contract for an amount which appears to represent $7,000 an acre.
I don't know if all auctioneers do it, but I video or audio tape every one of my auctions. I don't know if if it gets round down to it, if they have an audio of that auction or
No,
not.
I didn't. When I called, I just asked for a copy of the contract,
Right.
just because I thought if there was an executed contract, that would be the most telling thing.
I'm-
It wasn't mentioned. I didn't ask. I mean, it could have been. There could be one. I did not specifically ask, but.
But just for future reference, you could always, most auction, I think everybody here probably does the same thing. They audio tape their auction so that there's a good record of what transpired. Chair will hear and entertain a motion unless there's any discussion.
So what happened here is the auction company got a bad check for the earnest money?
It appears that this complainant says that they bid $5,000, but that when
But he
they went
stopped
to
payment
settle,
on the check.
stopped payment, and so it appears that the respondent has not been able to contact the person because he says that the complainant put a false address in the registration. The attorneys have tried to contact the complainant to get this money, and mail's been returned. It appears to have. It appears that the sale hasn't gone through because yes, the stop payment was issued on the check.
I move to go with legal's recommendation.
Been moved to dismiss the case. Is there a second?
Second.
Seconded by Ronnie. All in favor say aye.
Aye.
Motion passes.
May I ask just one question before we move on for my clarification? I've been operating under the assumption that under history for these headings, some of these licensees have been licensed for years and years and years, and they may have had a couple complaints that were dismissed and a couple with action. I've tried to clearly outline in the history what the action was. I've not put the total number of complaints because I didn't know that you all wanted to know if there were 2 dismissals and this thing. I figured you
Right.
were focusing on the action. Am I operating under the correct assumption there? Okay.
I mean, that's good information to have.
Okay.
I think the only reason I like to look at it is in case for smoker's fire, if they
Okay.
just keep on,
All right, so then this is okay to
Yeah,
let us.
great.
All right, thank you. That's all I have for the legal report.
Hey, Kimberly, if you'd like
Sir.
to give us the complaint comparison report under tab 4.
Yes, sir.
My books. See that newsstand down there? Wait a minute. There you go. Click in the middle somewhere, Bobby. There you go. Now you go. Got to have a pulse. Tab 4 is what you're looking for.
I'm weak.
There you go. Next page.
Okay.
We're ready.
I can't operate the touchscreen microwave either, so.
Currently, the performance measure for the Tennessee Auctioneer Commission stands at 89.66%, which is above the current 75% performance measure standard. Believe that is going to be raised to 80% in the coming year.
Okay.
So we're still doing well above average.
All right, good deal. And
And we are in the process of
you
closing.
back out the big group of them, how many total complaints have we got that are outstanding at this point? I think there's like 35 or 40 in that one bunch in there.
Less than 15.
Beautiful. Okay. Good deal. Next on our agenda is to talk about and
I
adopt.
have
Oh, go ahead. Go
I
ahead.
have a question.
Okay.
How are we handling complaints that you get a complaint? How long does it usually take to get it on the agenda?
It varies. Sometimes we have to request investigations, sometimes not. We had one that I would have presented today, but we had some companion cases where I haven't gotten in the responses for all of those, so I wanted to present them together. We have another one where we had a second complaint come in on the same company. I want to wait and analyze those both at the same time and send an investigator at the same time if we can to cover both of those issues. So it varies just depending on the amount of investigation we need for each one.
So normally, if a complaint is filed in April, just pick a month out of the sky.
It would depend, like I said, on if another complaint came in or if I needed to do an investigation. It also depends on our meeting schedule. If we don't have a meeting one month, that could delay it a little bit. I mean, I get them presented as fast as I can. I think there's only 2 in my drawer right now that weren't presented today, and that was, like I said, for the aforementioned reasons. One, I'm waiting for a second one to come up to see if I need to request an investigation. The other, there's some companion cases that I'm waiting to get from staff. But I don't have a drawer full by any means. I try to present as many as I can, but I try to get as much information, too, as I can on most
Thank you.
of them.
And the department has a standard operating procedure that allows X number of days for the respondent to respond. It also allows for the complainant to respond. As those things come in, we pass those along to Julie. The goal is to present matters for legal consideration by the board and dispose of them within 180 days of receipt.
We hit that target pretty well, I think. or-
Yes, sir, at 89%,
Yep, there we go.
almost 90.
Okay, we've got the 2015 meeting schedule in front of us. This is pretty much in line with the way it is every year. The only meeting month, there's 2 meeting months that we don't have meetings. One's in July and one's in September because of the NOLA NAA conference in July and the Labor Day holidays first Monday in September. Any other conflicts? I don't know when the TAA meetings are.
It's usually the first Sunday and Monday, so that would be the next weekend after.
Right.
I'm wondering, do we need to have a meeting every month?
No, sir, the statute only requires that you meet once every quarter.
That's correct. And I wonder if we met once every quarter or met only when we have business enough to last more than usually 2.5 hours or something, if it wouldn't be a substantial savings to the taxpayer to not have so many meetings.
Yes, sir, and Ms. Kropp and I meet monthly and discuss the amount of business, and I contact the chairman when we find that there is not going to be enough business. We also keep in mind that the legal report, in order to keep our matters from going over 180 days, we take that into consideration as well. So it's always evaluated prior to us actually conducting a meeting.
And we have canceled meetings when there was not enough business.
Yes, sir. I communicate with Chairman Morris on multiple occasions this past year via email and phone call regarding the amount of business and
I think
We
we
would have
skipped.
to make what, we have to make what, 4 times a year?
4.
Once a quarter.
Once a quarter.
Yeah,
And that requirement necessitated this meeting today.
yeah.
Because you do not meet in July and September.
So we'll be looking at the October meeting. If we don't have enough business, we can move it to November.
Well, actually,
Except we got a formal hearing, I think, in
we have a
October.
rulemaking hearing in October.
Yeah, the
Yeah,
rulemaking.
that's right.
And a formal hearing slated
That's
for
gonna be a big
November.
day.
Yeah,
Believe
so
that's
October,
still-
November for sure.
Yes, sir.
December can be iffy.
Absolutely.
Well, I think we skipped last December.
I believe we did as well. But
That would be on your shoulders, Mr.
this calendar assures that we have the meeting space reserved. It's posted, and we always post.
And we can always
a
cancel.
year in advance. We always post the cancellations on our website, and they go out to the media and various others. I do actually need you to
Yeah, I know.
approve.
We do need a motion to adopt the meeting schedule for 2015 as presented.
I make a motion to adopt.
Ronnie has made the motion to adopt it. Is there a second?
Second.
Seconded by Bobby. All in favor say aye.
Aye.
Guys, ayes?
Aye.
Aye. All right, motion passes. All right, we've got a legislative update on tab 6.
Yes, sir. Okay, there were two public chapters this year that affect the Tennessee Auctioneer Commission mostly indirectly. They're not anything that affect your actual statutes and laws. The first being Public Chapter 815, and this is relative to the restoration of citizenship. This information is all listed there and was provided via email on Notify, as well as being posted on our website. And this allows certain persons beginning January 1st, 2015, who have had their rights of citizenship restored to petition the court for a certificate of employability.
And what impact would that have on this commission in terms of just being a citizen
It would
for
allow.
an application? Is that what you're saying?
It relates to if they stated they had a felony.
Right. If someone that had a felony in the past could apply to a court for this certificate of employability, which would basically state that they were, I'm not sure that for purposes of actually in practice courts issuing them, the effective date is January 1st, 2015, so they've not actually, to my understanding, started to be
Right.
issued yet. But the effect of it would be to say this person is employable, and the legislation effectively states that the certificate of employability preempts any rule that a commission or board may have, which says a person cannot get a license if they have a certain felony. Would not, to our understanding, overrule any statute. And it requires that if a person has this certificate of employability, that before denying licensure, that the board or commission would have to consider that person on a case-by-case basis instead of just blanketly refusing a class of persons with a certain type of felony on their record if they had this certificate under this legislation. How this comes in for some boards, including real estate, I know specifically because I work with them, they have a specific rule that someone cannot be licensed for a certain period of time if they have a felony conviction, and we're having to tweak that rule a little bit because it would be overruled by it. You all don't have a rule of that type, so I don't believe it would result in the necessity of any rulemaking for you all. But
I don't see
basically-
this having a major impact on the way we conduct our business.
And I'm not sure how many of these we'll even actually
Right.
see, but it's just something to be aware of, just because it is something that technically could affect us if it comes up.
Okay, the next one.
Public Chapter 881. This act requires each board and commission, in consultation with the Division of Regulatory Boards, develop a plan to create an apprenticeship program for use by such board or commission. And basically, given the fact that the auctioneers already have an existing apprenticeship program, the legislature has asked a series of questions related to apprenticeship programs. So we will be, Ms. Kropp and I will be working together to answer those questions using the existing auctioneer plan, and we'll actually be presenting that to you in October. in order to meet the December 31st deadline. So there's really no action needed, just mostly informational purposes. And a little heads up that we will present that at the end of next.
Many of the commissions don't have this, and they would actually be discussing a potential apprentice program. You all do, so it's a separate set of questions. But by this legislation, we are required to submit the report. We're going to start compiling some answers and plan to have a draft of it for you all to review and approve at the next meeting. But since you do have a statutory and rule scheme outlining your program, it should be a little bit more just for your information, for you to approve the information we come up with for this report.
All right, got it. All right, next on our list, do you have a recovery account claim information?
Yes, sir. At last month's meeting, claiming from the recovery account came up, and this document on tab 7 is a document very similar to the Real Estate Commission's recovery account claim process that is posted on their website.
Basically, Chairman Morris, I believe, had asked if we had kind of a user-friendly version of this for the public to look at on our
Right.
website. I thought I had done one for real estate, and that's what I was thinking of. So since the past meeting, went through the statute, kind of tried to break it down maybe a little bit more in a timeline type fashion, because the statute can be a little confusing, and just wanted you all to look at this and see if, if it met with your approval to put on the website, just to put out there for informational purposes for anyone who might have, not be aware of the account or have a little trouble with the statute, but just to kind of try to break it down in a little bit more of an understandable fashion.
Well, let's just take a minute and go through it and give us a second. Well, I think that clearly states the steps to take and what the law covers and what it doesn't cover. I think that's good information to have, and I really would like to have that on our website. From my standpoint, would anybody like to talk about it or discuss it or? Yeah, it's good. It's good information. I don't think it's anything we need to adopt or anything, but I appreciate the information, and I think it's good that we.
Might just be best to adopt it.
Okay, we'll do that. Bobby?
I move to adopt this to our website.
Second.
Hey, there you go. Been moved and seconded. All in favor say aye.
Aye.
There we go. You have your permission to post that to the Tennessee Auctioneers website.
Thank you, sir.
No, I never really thought about how that worked. That's good information. I didn't know that,
Well, we all knew it was there. We just didn't know what it
Yeah,
was.
That's good information.
Next item is citation information.
Yes. And actually, I'll invite Mr. Driver up, as you may have questions that he might be best for him to answer. 6219-126A, the administrative director and the investigator acting on behalf of the commission are authorized to issue citations against person acting in the capacity of engaging in the auction business without a license in violation of this chapter. This is something that administration is going to begin doing. We're currently drafting a citation as well as a cover letter that goes out to people, and this is focused at those who are operating in our state unlicensed. And the citation allows the administrative director to, the citation is very similar to what you would see in a consent order. but it basically allows the person to respond and pay a penalty for operating. And if I'm using any of the incorrect words, Michael, please feel free to correct me. But it would allow them to settle the matter and avoid having to present it to the commission and going through all of the formal processes. They can appeal it, and then it would be presented to the commission.
Let me make sure I understood what you just said, and if I understood it, I don't like it. A person can operate an auction in the state of Tennessee without a license, and if he gets caught, you're going to send him a fine, and he can send the fine in, and that's the end of it. If he promises he'll never do it again. Is that what you're saying?
And the commission never hears anything about it?
And he can sell a $500,000 farm at 10% commission, make $50,000. How much is his fine?
Excuse me, I'm
Cost of doing business.
Michael Driver, Chief Counsel with the Regulatory Boards Division. Hope y'all are doing good this morning. Under the statute, the civil penalty is in an amount of $50 to $2,500 per violation. Of course, each day of a continued violation is a separate violation. If I understand, I don't know off the top of my head what your standard civil penalty range is for a violation of unlicensed activity.
Well, we got one for A1, like we just discussed in one of those matters. Basically, A1, which is acting as an auctioneer without a license, is $0 to $1,000. If it's a real estate auction, there's a separate subsection and a separate range of $0 to $1,000 for that as well. So essentially, for like the one we just considered, which was a real estate auction, the commission put $2,000 in the consent order. But that necessarily wouldn't maybe always be the case if it wasn't a real estate auction.
I'm sorry. I want to reverse a little, guys. I want to give you a little bit of historical data. My name is Rachel Powers, and I'm the Program and Policy Director for Regulatory Boards Division. Just to give you a little bit of background information on this, you all have had the statutory authority under this section since 1999. I don't know if historically you've taken authority to use this in the past or not. But Deputy Commissioner Giannini has been looking for administrative ways to go ahead and be more efficient and effective in our regulations. And you, along with a couple other programs, have the statutory authority to do this. So I have been working with Michael Driver here and looking at which programs can do these citations and going ahead and getting in front of taking action against these unlicensed individuals. It's only unlicensed individuals, and this code section allows for the administrative director of the program to send this citation. It's almost like a ticket. And if the person wants to go ahead and pay a civil penalty in advance, it's just a quicker way of regulating these individuals. And they can pay the citation, and then it goes on your disciplinary action report like it would in any other matter, and it's documented. If they don't pay within the 15 days set out in the citation, it comes to you just like any other matter comes to you. So effectively, if the same procedure happens, it's just a more efficient and effective preemption to your regulatory authority that's already set out in the code. Does that help any at all with understanding the process?
Well, to Howard's point, I mean, there's two things here. One, do we have the authority under state law to issue a cease and desist order prior to the auction taking place if we know they are advertising an auction by a unlicensed company, either for real estate or auction?
I would defer to legal counsel on that.
We've never done that before. It's my understanding that with the AG's office assistants, we can, but like I said, while I've been here, I've never done that.
And if you want, I don't have the answer to that here today. That's something I can certainly look into to see if there's the answer in your code.
Well, this
Because to Howard's point, once they've had the auction, and they, no matter what it is, a $2,500 fine is like paying a one-time license fee to go ahead and have the sale. And so what? I paid the fine. That's not a big deal. And
I think we want to guard against it just being a cost of doing business, like a
exactly.
newspaper ad or something like that.
Exactly.
What the heck? Go pay the fine. This is part of your sale.
And so I
See what I
would,
mean?
I much prefer, once we know that there's a case in point, I mean, there was a big absolute auction advertised in Nashville by an unlicensed company, and this was a $12 million piece of property. A fine doesn't mean anything to them. I mean, they're glad to have the auction and pay the $2,500 fine. That's not a big deal. But if we can issue a cease and desist and to allow that auction not to even take place is a more powerful tool, in my opinion, than a $2,500 fine.
And I think that everything should come before this board before any action is taken by anybody.
I think we're looking for expedience.
Well, we've been doing okay, and I don't see where that if you send somebody a letter from up on top of the hill that it's going to help anything. The auction commission and the board that's our sole purpose of being here. And if somebody wants to write these citations or whatever it is, they should come down here and bring it before the board before it's done.
This if I don't know if y'all have your code in front of you at all, but this
Okay.
6219-126 is within your section to authorize your administrative director to do this. Other programs such as contractors and home inspectors and the scrap metal programs have this authority as well. And I believe that within the citation, it is a cease and desist, this violation. And if I'm understanding the commission's laws and rules, is your civil penalty is $1,000 per day per violation, as with most other boards and commissions are too. This gives them the authority to issue $2,500 for each violation, which is higher than the $1,000 per day per violation under the citation. And if they don't cease and desist within the time that they receive it, we could send them another one if they're continuing to act.
Why are you wanting to do it before it comes before the board?
It's just a precautionary, more effective and efficient way to go ahead and get them out there. If they find out, if there's an advertised, we're having this, we could go ahead and send them a citation to say, hey, you're in violation, you can't do this, and that may prevent them from doing it.
Well, we just discussed that we're having a meeting once a month. Are you going? You think you're going to be doing that faster than once a month?
Well, as soon as we got the information, we would send it. They have a 15-day response time, so it would be a little quicker.
But not very much.
And we're just presenting this today, guys, because it's something that we want to look into. I don't know how often your complaint list actually has unlicensed activity across the board. Other programs have a lot of unlicensed activity, and this is going to be really effective and efficient. This is just allowing you to take advantage of a statutory section that's out there for you.
And I actually brought, just for your consideration, extra copies of it, so you'll at least have that copy of the code section with you for y'all. Little light reading for you.
Well, I do know that we're seeing a tremendous increase in the number of companies coming into Tennessee unlicensed, either as auctioneers or as realtors, to hold real estate auctions. I don't know how much we're seeing personal property auctions taking place, but for real estate, for sure.
And the worst thing about it is most of them turn out like this bankruptcy auction deal. Most of them turn out like this bankruptcy auction deal we were talking about earlier, where they end up.
Right.
So
We would like to
under
do
Section B-
anything that y'all see that we can do to stop this activity. That's my
And
point.
we're just trying to look at everything to help
Right.
you guys. We don't want to take over what you do. Y'all are put here for a reason. You're appointed by the proper authorities for a reason, and your expertise is needed. And if you look at under 6219-126, 3B gives you the authority to promulgate rules and regulations about this whole section. And I don't know that you have ever done this in the past because I don't know your historical information, but if this is something you wanted to look into doing rules for to make it more specific for the administrative director, you have the authority to do that as well. But we want you to take advantage of all the statutory authority that's out there for you to regulate.
And we do too. So, is there any action that we need to take on what you're presenting to us today?
There's not.
Okay. But like I said, we see a lot of this, and we'd like to have as much teeth and as much speed and as much efficiency as we can in stopping this activity as much as possible.
And
Mr. Driver, we appreciate your efforts.
And I would make one note. I think there were some questions as to how this is different from the current system. And the biggest difference is the enforcement mechanism, which is this is if they don't appeal, if they're sent the citation and they don't send a correctly served and they don't send a written request to contest it, the citation is entered and the discipline is final. Under the, I guess, standard system, a consent order is sent that they have to either actively agree to. If they don't agree, then it goes to a formal hearing. And I think that's the biggest difference, and the biggest difference in the expediency is maybe not in the kind of front end notice that there's been a potential violation, but on the enforcement and back end. I just wanted to, I guess, touch on that.
I guess even if they paid the 2,500, if they didn't stop, they're still.
I think you're saying for
Illegal.
every day they don't do it,
Yeah,
that's another $2,500. And so basically $2,500 per day is what you're telling me. Am I
If that's
am I
what
hearing
your
that
rules
correctly?
provide. Most programs
No, I don't
rules
think ours
do provide
provides that.
per
I
day
think
per
she's talking about
violation, so.
Dollars, and if they don't pay it, they don't pay it, and
Well, this is for
It's
each
end
day,
of-
for each day.
it can't be for each day.
Well, every
If
continued.
if I do an auction and I don't have a license, and you send me a citation for $2,500, and I don't pay it tomorrow, it's 25 more hundred. If it's 20.
No,
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 if
no,
you
no.
started advertising an auction today and we sent you that, as soon as you notice your receipt of that, I think that the legal counsel could then look and say, you know, at this day you had notice and you continued per day per violation. And then the day you had the auction, if that's the end of it, then you've advertised so long and you've also had an auction. Does that make sense?
So what would be the maximum fine you could give somebody?
I think as long as they continued to violate the chapter.
$2,500 for each day they advertise it.
Now, you would have to show a separate violation for
Right.
each day. If they took an act, if they ran an ad one day and it didn't run again, you don't typically get to say that that ad was a continuing
Right,
violation just because, I mean, that ad was a
If they placed
violation.
another ad, you did that.
If they,
another-
correct.
That'd be another $2,500 fine,
Per
right?
day, per
Okay,
day.
But what is the maximum fine?
There's no limit.
The maximum would depend on how many violations they committed.
They can-
It's
if they
$2,500
committed 100
per
violations,
violation.
It'd be $2,500 times.
$2,500.
Yeah.
Basically, as many days as you could prove that ongoing violation would be the maximum, is what he's saying. You couldn't just assume ad A ran for 3 weeks, but if you could show it ran for 3 weeks, you could multiply
But
it.
is running the ad, is running the ad a violation, or is doing the auction the violation?
Both can be considered a violation because the way your statute is worded,
Well, I'm glad all this is,
102 is
Come to light.
to act as or advertise. So, you know, even if you have someone that the advertisement of it is, you know, technically a violation. You could also say the day that you run the actual sale is a violation of it because that's
Even a
acting as.
Facebook post
Ad may
saying,
be
you know,
running
come
on
to
the
our,
website every day.
well, I mean, even if you ran a Facebook post, that counts as advertising.
well, why we never pursued this before?
Under this statute.
Yeah, I mean, we were always been told that the maximum penalty is $1,000 or $2,500. Nobody's ever, it's never been brought up that it was $2,500 for advertising it 3 times and $2,500 for doing the sale.
Well, for the $2,500, that's under this statute that has not been utilized, at least to my knowledge, since before I was the attorney. But for the regular civil penalties for $1,000 per day, I mean, the maximum for the violation is $1,000. You can multiply it by the days, but we have to have that hard proof of each day of the violation. So,
We haven't looked for that, to answer your question. I think this gets to the heart of what we're here to do, and that's to protect the public against unlicensed activity. So, is there anything else you want to bring up?
I just wanted to remind everyone that at your next meeting, we will have a rulemaking hearing for the rules. It's been many months coming, but we're nearing the end. Commissioner Chairman, do you have anything about the NOLA conference?
Yes, I was going to bring that up, and I'm glad you mentioned it. We did have the Neola conference at the NAA conference and show this year. Best attendance we've ever had. We've got, our membership is up a little bit. If y'all don't know what NOLA is, it's the National Association of Licensed Law Officials of Administration. But anyway, we had an election. I'm the new president of NOLA. So, I don't know whether that's good or bad, but we're going to see if we can't grow our membership and get other states to join in. It's a good sharing across all states of licensed law activity. And one thing we're going to try to do is create a bulletin board for if we see auction activity from one state that can pour into other states, we're going to try to have a clearinghouse for information for those kind of offenders that are just snubbing their nose, exactly like we're talking about today, people that just go around the country and just have an auction wherever they want to and just pay the fine if caught. A lot of times they never get caught, they never get turned in, they just go about their business and they don't care. So anyway, but yes, that's kind of what's going there. We had a good. I tell you, the conference and show this year. I wish you guys. We're going to be in Dallas or just north of Dallas next year. We had great attendance in Louisville this year, and it was probably one of the better conferences that I've been to, and I've been to most all of them in the last 10 years. But this one was really well attended, really well done. And I think Dallas next year will be great. So, Bobby, if you can make it next year, I know Louisville's too far to drive for you, but
Dallas will be about right.
so let's try to do that next year.
San Antonio was awful good.
San Antonio was good. Anything else, guys? I appreciate you being in. Howard, it's a long drive from East Tennessee. Appreciate you coming in, and we look forward to serving under you for the next year as chairman of the commission.
It'll probably be a challenge.
I'll entertain a motion that we adjourn.
I so moved.
Moved and second, we adjourned.
Justin, are you just lost today or just ain't got